We're good. This is People of the State of Michigan versus Douglas Heckerman, docket number 19-119FC. And, excuse me, this is the time set for the defendant's motion for a new trial. And if I could have counsel appearances first, please.
Jessica Shaw on behalf of the people.
Good afternoon, Your Honor. Tim Doman on behalf of Doug Heckerman.
And then for the record, Mr. Heckerman is present remotely. And it's your motion, Mr. Doman. You may go ahead.
Thank you very much, Your Honor. So I want to mostly focus on the first issue because I think that is the stronger and dispositive issue here. And I don't want to belabor every argument I made in the brief. I'm sure the court's reviewed it. I mostly just want to respond to some of the points made by the prosecutor in their brief. So I think that Ms. Shaw has made really valiant efforts in her briefing, but she can't escape what trial counsel himself said. Quote, "It is our theory of the case, our entire theory of this case, that Danielle is fabricating these allegations in an effort to save her mother." And then he goes on to refer to Danielle being previously separated from her mother and trying to prevent another separation. And based on counsel's questioning of Nancy Huddleston outside the presence of the jury, we all know what he was referring to. The theory was that Danielle fabricated the allegations so she wouldn't be removed from her mother again. And I know trial counsel made reference to saving her mother and things like that. But what he was really getting at was that Danielle didn't want to be removed again and have to live with Mr. Heckerman. So that's what prompted these allegations. So that was trial counsel's theory. And yet he failed to present any evidence at all supporting it. So it's not the typical ineffective assistance case where sometimes you're playing Monday morning quarterback and saying counsel should have done this and not that. We're saying that counsel executed his chosen strategy objectively unreasonably. And to his credit, though, I think trial counsel settled on what, in my opinion, was the most viable theory. In these kinds of cases, jurors are always going to ask themselves, why would she make it up? And in this case, there was a good answer to that question. She didn't want to be removed from her mother and go back to Mr. Heckerman, just like the last time her mother was arrested. But by not doing the legwork to get the necessary facts in front of the jury to credit the motive to fabricate defense, trial counsel performed efficiently. Now, the prosecutor points to different arguments that trial counsel raised in terms of physical impossibility, some inconsistencies, etc. But those arguments were all designed to orbit around the central idea that she was making this up to avoid another removal. And that central idea really gave meaning to those other ancillary arguments. And the prosecutor also says that only Danielle could testify to what her motive is, but that's not what the law says. Motive and intent can be inferred from circumstances and actions, and the court even made that point itself in sustaining the prosecution's objection at trial. So really, given that it would have been very easy for trial counsel to tee up the factual predicate for this motive to fabricate defense, I think we pretty much have deficient performance per se. And the prosecutor makes reference to the length of jury deliberations in this McLeod case, but that's a pre-Strickland case that's never been cited in another court of appeals decision. It's no longer good law. But leaving that aside, I think the length of jury deliberations shows just how close this case was, even with trial counsel's mistakes, and the likelihood of an acquittal if the motive to fabricate evidence had been presented. And that takes us to prejudice. And just one point to start, the prosecutor makes some reference to older case law on depriving the defendant of a substantial defense. And I don't mean to put the prosecutor on the spot here, but that line of cases was very recently overruled by the state Supreme Court in People v. Allen, which I think is either from January or February of this year. But putting that aside, I think we can show prejudice in two ways. First, under Weaver, we can establish prejudice by showing that the trial was fundamentally unfair. And the prosecution suggests that we need to show a structural error, but that's not what Weaver holds. Weaver explicitly rejects a mechanical approach to prejudice. In here, I think the trial was fundamentally unfair. From day one, Mr. Heckerman has maintained that these allegations were fabricated after the mother's 2018 arrest. He had a fundamental right to present evidence supporting that theory to the jury and to argue it. But he was deprived of that right because trial counsel didn't take these really basic steps to investigate the case and gather evidence to support the motive to fabricate theory. And I think in this kind of situation where the entire theory of the defense is absent from the trial because the defense attorney didn't do his homework, we can say that is a fundamentally unfair trial, that regardless of the strength of the evidence, the defendant was deprived of his basic right to give the jury his side of the story. In the alternative, I think we can show Strickland prejudice under the traditional reasonable probability standard. I mean, this was a he said, she said case. Nothing inescapably established Danielle's allegations. And the Supreme Court recognized in Trachtenberg that motive to fabricate evidence is particularly compelling in child CSC cases. So if the jury had heard that Danielle reported her allegations right around the time her mother was arrested, I think it could certainly make one juror question whether she's telling the truth. I mean, she doesn't report when the counselors come to the home. She doesn't report when she's initially returned to her mother. She waits years, and when does she report? When her mother's in trouble again, there's a potential concern that she's going to be removed. Now, the prosecutor says that by reporting the alleged abuse, Danielle could not have stopped the mother from being arrested or another removal. But we're not looking at this from a lawyer's perspective. We're looking at this from the perspective of a young teenager and what she might imagine the consequences to be. And the prosecution also suggests that the timing of the disclosure and the possibility of going back to Mr. Heckman actually enhances Danielle's credibility. But, and I think this is crucial, nowhere has Danielle said that she finally reported because she feared going back to Mr. Heckman, not at the forensic interview, not at the prelim, not at trial. You know, if she had said from the get-go that she decided to finally report this because she was afraid that she'd have to go back to being abused by Mr. Heckman, this is a very different case, right? That's not what happened here. And I find it very peculiar that, as far as I can tell, there's really no reference made anywhere in the record or in the discovery of the mother's 2018 arrest. And that begins to look like you're hiding something. So really, the timing of the disclosure is more helpful to the defense and goes to the idea that Danielle made up the allegations so she wouldn't be taken away from her mother and go back to mean, scary Uncle Doug. And really, you know, it's not up to the defense to prove any of this, right? All we need to do is create reasonable doubt. And I think with the motive to fabricate evidence properly put to the jury, at least one juror could have harbored reasonable doubt. Now, turning to the Daubert issue, the prosecutor relies on the Spalding case, which frankly, I think was wrongly decided. I don't think will stand for very long, but even leaving that aside, it doesn't apply in this case for one simple reason. This case was tried before Spalding, and deficient performance is gauged by the law as it stood at the time of trial. And given the amendment to MRE 702 and the Michigan Supreme Court case law interpreting the amendment, pre-Spalding, I think this court would have felt compelled to assess Tom Cottrell's testimony for reliability. And it's interesting, in the Supreme Court's final order in the Tomasic case, they reversed based on a vouching issue, but they also directed the trial court on remand to conduct a Daubert hearing on any expert testimony. Now, if Daubert doesn't apply in this setting, why would the Supreme Court be ordering a Daubert hearing? So again, pre-Spalding, at least, I think this court would have felt compelled to hold a Daubert hearing on the reliability of the testimony. Now, in terms of whether the testimony was helpful, I'm a little nonplussed by the prosecutor's argument. To the jury, they said this is common sense, this meshes with your common sense, but on appeal, they're saying something different. So which is it? And that raises the doctrine of judicial estoppel, which holds that a party cannot assert on appeal a position inconsistent with a position the party asserted at trial. But leaving all that aside, as I said at the beginning, I think the first issue here is dispositive. I think we've made enough of a showing to be entitled at a minimum to a Ginther hearing. So we'd ask the court to order that Ginther hearing, and we'll be asking the court to order a new trial at the conclusion of the Ginther hearing. Thank you, Your Honor.
All right, thank you. Ms. Shaw?
Thank you, Your Honor. With regard to the first issue, defense counsel argues that the evidence of Rebecca's arrest would basically be the thing that proves that the victim was fabricating this entire lie in order to save her mother. And in opening, trial counsel does state that the entire theory of their case is that Danielle lied to save their mother. And he says this, and he doesn't say anything else after. He doesn't bring up the arrest. He doesn't belabor this theory. The majority of his opening is arguing a physical impossibility. And then at proof, when proofs come in, he does bring in a testimony to support that physical impossibility. The fact that Danielle didn't lie is also supported by the manner of her disclosure. If this was a fabrication and she was trying to get Mr. Heckman in trouble or trying to not be placed back into his home, she would be reporting this to the police or telling her mother or telling somebody who can take some type of action to prevent that from happening. But that's not the way that she disclosed this. She disclosed to her peers and told them not to tell anyone. This is more consistent with someone who doesn't want anyone else finding out about this. So that also goes against any kind of fabrication. The most that the evidence of Rebecca's arrest has, as far as evidentiary value goes, is to support or to give alternative reasons for her cutting, which the trial counsel had already argued, such as being bullied or having mood recently. CPS wasn't even involved, so being removed wasn't even an option at this point. If the court does find that not introducing this one piece of evidence is deficient performance, then the defendant was not prejudiced by that performance. And I did talk about jury deliberations, and I believe that's still good law, that the length and nature of jury deliberations also weigh towards how ineffective or effective counsel was. And here the jury deliberations lasted longer than the presentation of evidence, and they initially came back hung on 3 of the 4 counts, and eventually still hung on 1 count and found him not guilty of 1 count. So that weighs against the claim that he was ineffective. Weaver also specifically states that just because an error is structural doesn't mean it's automatically prejudicial. That's what that case is saying. It's not saying anything otherwise. And so in this case, the error, it wasn't fundamentally unfair. If you look at the examples of other rulings where the courts have found cases to be fundamentally unfair, that's where someone was denied a counsel, where reasonable instruction or reasonable doubt instructions were not given or wrongly given, where elements of the case weren't even given. That's not what we're talking about here. We're talking about presentation of the evidence and how it was presented or not presented, and that's more of a trial error. So the harmless error analysis would apply. We would look to whether the defendant was prejudiced or not, and he was not prejudiced given the other evidence in this case and given the other arguments made by defense counsel and the minimal probative value of Rebecca's arrest. As for the Daubert challenge, the case law does say that is consistent with trial counsel's claim that making or raising such a motion would have been frivolous. And even before Spalding, non-intuitive victim behavior has always been admissible, and it was not subject to the Daubert standard. So Spalding doesn't change any case law. They rely on still good case law when they make that ruling. The cases that were overturned with Mr. Cottrell testifying, that had nothing to do with his qualifications or his testimony that was relevant to this case. That had to do with opening the door, as I explained in my brief, to a certain line of questioning, which was inadmissible, or testifying about syndrome evidence, which is not applicable here. So there was no issue with Mr. Cottrell's expert testimony or his expertise. And so Spalding does rely on good law at the time. The law hasn't changed. Spalding doesn't change any laws when it makes its ruling. So that law was still in effect when the defendant was on trial, and Mr. Cottrell was not subject to that scientific reliability. So as far as helping the jury, Mr. Cottrell's testimony did assist the jury. The voir dire questions, the answers during voir dire, the statements made by the jurors on what they expected the testimony to be, that is evident that they certainly needed expert testimony to be able to understand non-intuitive victim behavior. Now, we're not changing positions. If you look at the counsel's closing argument, the prosecution isn't arguing that it's your common sense, you should have known this. She's arguing that it aligns with your common sense. So basically she's saying what Mr. Cottrell testified to isn't nonsensical. If you think about it, it aligns with your common sense. It makes sense. So this isn't something that she's saying you should have known this, it's common sense. So we're not by any means changing positions. And her argument was just saying that it aligns with your common sense. So it's not a switch in positions. We're not now saying that what should have been common sense is no longer common sense. And I believe I was pretty detailed in my brief, so I know the court has reviewed it. If the court doesn't have any questions, then I'll rest on my brief.
I don't, thank you. Mr. Doman, rebuttal?
Thank you, Your Honor. Just brief. Thank you very much. And yeah, just briefly, I know you have a docket behind us. So just to respond to a couple of points from the prosecutor. First, I think I heard the prosecutor say that we're presenting this as proof that there was fabrication. We're the defense. We don't have to prove anything. All we have to do is raise a reasonable doubt. So that's, again, we're not saying this is proof of anything. And if we were to hold an evidentiary hearing, the witnesses aren't going to come in and testify and say, oh, you got us. They're going to deny it. Of course, they're going to deny it. But the question is, if this had all been presented to a jury, could this cause at least one of them to have reasonable doubt? Now, the disclosure to the sister, a couple things. Just because she said she disclosed to the sister first doesn't make it true. The record is very garbled on how these allegations came to the attention of adults. It's not outside the realm of possibility that the sister could have been part of this conspiracy under the defense theory. And where is this cousin that she supposedly disclosed to? She never testified at any point. But even accepting that Danielle disclosed to her sister first, really that could be seen as her testing out the allegations and whether they would be believed. But again, at the end of the day, it's not up to us to prove anything. And I think the important point is the proximity in time of the disclosure to the mother's arrest. And really that does look suspicious when she had all these other opportunities to disclose. So just on Weaver, just briefly, nowhere does Weaver say that to meet the fundamentally unfair standard for prejudice that you need to have a structural error. And I should say that Weaver, it's a fairly new case. It's kind of flown under the radar in some respects, but Weaver really refreshed this idea that in every case you don't need reasonable probability, that there's going to be cases where there's fundamental unfairness. So it's a little bit newer, to raise this kind of argument. But again, I think really all the case law on the right to present a defense dovetails with the fundamentally unfair nature of this trial. And so just to wrap up here, this is a capital case. My client is in prison for 25 years at a minimum. It's a life sentence given his age. I think we've made a pretty substantial showing that there was a major error made by trial counsel. And we're not asking for a new trial today. All we're asking for is an evidentiary hearing. I think we deserve that. Thank you, Your Honor.
Thank you. Well, the first part of the test is whether trial counsel's performance fell below an objective standard of reasonableness. And the argument has been made here that the trial counsel made this motive to lie his entire strategy, and then he didn't deliver. And he didn't deliver because he had a way to put it into evidence, the arrest of the mother, that is, but he didn't use it. And instead he used a failed, on multiple levels, failed attempt to put it into evidence. It is true that in his opening statement, trial counsel put this as a he said, she said case, said that Danielle had lied to save her mother. But in actuality, he did not announce a strategy of only showing that there was an arrest of her mother that triggered a false accusation. In actuality, he introduced evidence, and that's far more than just announcing an opening statement. He actually introduced evidence and argued multiple different theories and defenses. The first one was Danielle's credibility. which was basically the defense of it didn't happen, a different way of saying she lied. But he attacked Danielle's credibility by impeaching her with prior inconsistent statements. He addressed the failure of Danielle to report this earlier, even when she was given a safe environment, or at least a temporary safe environment in which to do so. He brought out her lack of fear of the defendant and the fact that while she was living with the defendant, there was no change in her behavior. He brought out, of course, the obvious delayed reporting for a matter of some 3 years. And he also brought out multiple alternative and even credible reasons for Danielle's cutting behavior. That was one, I'd put that under the category of Danielle's credibility. He attacked all of that, and he did it again with actual evidence. And then he also addressed physical impossibility, and he gave 2 reasons for physical impossibility and also introduced evidence about it. One was that the argument was that the defendant's penis was not accessible when he was wearing pants and in a seated position. And the other was that he couldn't achieve an erection. Then he went to a third area of defense, and that is lack of injury to Danielle. He brought out the defendant's large, rough hands and Nancy's testimony that she did Danielle's laundry and never saw any evidence of injury. And then finally, he brought out the defendant's cooperation with police, something that will often ring true to a jury, that a person who didn't do this would not meet, in this case, 2 times with the police and cooperate fully with them. So even though there was a statement, an opening statement about the theory of the defense, that was merely the defense attorney's opening statement. When it came down to actually producing evidence, which of course is the most important part of the trial, the opening statements not being evidence and the jury being told that, the defense produced all of this evidence, or elicited all of this evidence as multiple ways that the jury could look at a defense in this case. So I just can't, I understand the argument that trial counsel did make a mistake, and it can't be denied. The record shows that trial counsel made a mistake. Trial counsel wanted to introduce evidence of the mother's arrest, and he did not know the proper evidentiary way to do that. And appellate counsel has demonstrated that there was a way to do that that would have passed muster under the rules of evidence. But every error is not a falling below the objective standard of reasonableness. There were, again, multiple ways in which she lied, this didn't happen, he said, she said, it isn't there kind of defense was presented. And so the one mistake on not being able to get in the mother's arrest, I don't think overall evidences counsel's performance falling below an objective standard of reasonableness. And then I'll go on, I mean, that could end it, but I'll go on and address these other things because I have to say that I'm not going to get in, it doesn't matter whether this alleged error was a structural one or not. The argument here is that the defendant was deprived of a right to present a defense. And I don't believe that is true, again, because the defense was presented that she lied. The defense was presented. If someone lied, then by definition, they had some motive to fabricate. The defense was presented that there were multiple reasons and ways in which it could be shown that she did fabricate this by inconsistent statements, by lack of consistent behavior, all of the things that I've just described. So whether this was structural or not, whether structural error requires any further analysis or not, I just can't agree that the defendant was denied the right to present a defense. He actually was given a rather robust defense. It just failed in the one respect of introducing the arrest of the mother. Turning then to the next step in the analysis, was there a reasonable probability of a different result if the jury had heard the evidence of the mother's arrest? And I will dispense with any analysis of the length of deliberation, whether that's good law or not. Just as a trial judge now for 16 years, I would not put any weight whatsoever on a fast or a long deliberation. There's all kinds of things that happen in the jury room. Some of them are not even directly related to the actual proof of the elements. I just would not put any emphasis whatsoever on the length of deliberations. I think it makes for a better analysis to look at what the actual evidence was and assess whether there was a reasonable probability of a different result. So the defense has brought out 3 points. One is that Danelle's testimony that she didn't believe she'd be removed from living with Heckman, even if she reported the abuse, is suspect because she had just been removed from her mother for less serious reasons. I think the problem with saying that it's suspect is that the jury already heard this testimony and they assessed it, albeit in a different context because it was explaining the delayed reporting. But to say now that testimony that the jury already heard would be reasonably probable to change the outcome, I just think is extremely doubtful and highly unlikely. And then the other things that the defense says, the other 2 points, are that Danelle's testimony that the defendant got mad and yelled and was scary fits with her desire to stay with her mother. The problem with that is so does being sexually assaulted by the defendant fit with her desire to stay with her mother. But again, the jury had evidence that Danelle preferred living with her mother to living with the defendant because she and her sister as well were very explicit in their testimony about not liking living with the defendant. So, you know, that by itself provides a motive. There was a good deal of testimony about how Danelle felt that the defendant was mean to the girls. He yelled at the girls. He didn't like how they cleaned their room. He threw their things around, etc. But the defendant dovetails that in with the timing of the mom's arrest and the disclosure, Danelle's disclosure, and says that the timing of the arrest and Danelle's disclosure could cause the jury to connect the dots and surmise that the arrest prompted the disclosure. Well, it could have, but that's not, prompting the disclosure is not the same thing as saying that the jury would have seen the mom's arrest as prompting a lie. There was, again, plenty of evidence that the defense brought out that could have shown the jury that Danelle was lying. But the timing of the arrest, if the arrest had come in, would go more strongly to explaining the disclosure and the timing of the disclosure. And again, I don't think that goes to the core issue here. I think that many of these other things the defense brought out did go to the core issue of whether Danelle was making this up or not. So I don't think that the standard has been met. The defendant has made the point, and of course they're entitled to make a record. With regard to this issue, the issue of the evidence of the mother's arrest, the only thing the defendant has said is we're entitled to make a record, and that's their sole justification. Well, I think that a Ginther hearing is called for when the facts are not available already in the record. And here I think we have a rather complete record that the defense attorney did try to get in the evidence of the arrest and couldn't do it. There is a way that he could have done it. Appellate counsel has amply demonstrated that. No one disputes that the Danielle's mom was arrested on March 15, 2018. The disclosure circumstances were fully testified to. The testimony about how Danielle and her sister did not see their relationship with the defendant as positive is completely on the record. They saw him as mad and scary and he frightened them. And in addition, multiple other defenses were presented and are part of the record. I just don't think that the one more bit of evidence of the mom being arrested around the time that Danielle disclosed, and I would add possibly after the time Danielle disclosed, because the record was a little muddled on that. I don't think, though, that it would have changed the outcome in light of all the other evidence that the prosecutor presented, and more importantly, that the defendant actually presented. So I think the record is complete. I think it's undeniable that there was a mistake made with regard to introducing the evidence of the arrest. I just don't think, in light of all the other evidence, that that was a mistake that meant that it would have, there's any reasonable probability that it would have changed the outcome, or that it showed that counsel's performance fell below an objective standard of reasonableness. The second part of this is that the defendant's claim is that the defense or trial counsel was ineffective for failing to raise a Daubert challenge to Thomas Cottrell's testimony. Counsel's not ineffective for failing to do something that would be unsuccessful anyway or meritless. I realize that the case was pre-Spalding, but even pre-Spalding, this court has to go by the binding law from the higher courts. And at the time of the trial, binding law from the higher courts is that the Daubert challenge did not apply to behavioral expert behavioral testimony of this sort. So of course I would have applied that as the law at the time. Even at the time, if there had been a remand for in another case for Daubert type evidence, I still would be bound by the law that was in place at the time, and that was that Daubert did not apply to this behavioral science. So I think that the trial counsel was correct in concluding that such a challenge would have been frivolous. And then I just have to say there is another part of this, and I'm not sure if it's related to the Daubert challenge or if it stands on its own, but the appellate counsel has said that Mr. Cottrell's testimony should have been objected to as not being helpful to assist the jury. I think that also would have been a frivolous objection, even if it's separate and apart from the Daubert issue. And in that regard, the judicial estoppel argument is not helpful. I've applied judicial estoppel 2 or 3 times. It's applied in civil cases. It's applied in very narrow situations. I am 100% certain it does not apply to a prosecutor making an argument to the jury about using their common sense. It just does not apply in that way. The law at the time of the trial, the law as it remains today, is that testimony like Mr. Cottrell's testimony is helpful to the jury because, as we saw in this trial, it's often argued that some of these things like delayed reporting show that a victim is fabricating or make a jury believe that. It's counterintuitive otherwise, and Mr. Cottrell and others like him have assisted juries in order to show that it might seem counterintuitive, but here's why the delayed reporting makes sense. So it is very helpful to juries, and the law allows it for exactly that reason. Again, the defendant requests a Ginther hearing on this aspect of the motion as well. But this aspect of the defendant's motion is decided as a matter of law. As I've already indicated, and I don't believe that the defense is entitled to a Ginther hearing. So for those reasons, I am denying the defendant's motion for a new trial and for a Ginther hearing. And Mr. Doman, you can submit an order if you wish.
I'll do that. Thank you, Judge.
Thank you very much. And Mr. Heckerman, that'll conclude our hearing. So I'm going to disconnect the facility that you're in from my Zoom hearing so I can go on and do other matters.
Thank you, Honor.